WSGVR family and guests. I'm Mindy Ye, your 2024 WSGVR Education Chair. Welcome and thank you for joining our WSGVR Education Meet and Learn, which is held on the third Tuesday of each month. Just some housekeeping items. Would you please ensure your cell phone is on silent mode and all participants on Zoom will be muted. Thank you. For the very first time at WSGVR, we're excited to share with you Bankruptcy 101 with our special guest speaker, attorney, bankruptcy trustee, Wes Avery. Mr. Avery received his BA with the highest honors in economics and in political science from the University of California, Davis in 1980, where he was elected to Phi Beta Kappa and Phi Kappa 5. He received his MBA from Harvard Business School in 1984 and his JD from University of California at Los Angeles in 1991 with an emphasis in commercial law and bankruptcy. Mr. Avery has been a member of California State Bar since 1991. He is a panel Chapter 7 trustee and a Chapter 12 trustee for the Central District of California. Mr. Avery is certified as a specialist in bankruptcy law by the State Bar of California and by the American Board of Certification, which is recognized by American Bar Association and the American Bankruptcy Institute. He is rated AV by Martindale-Hubbell since 1999, rated 10.0 by AVO, and has been designated as a super lawyer since 2006. Mr. Avery has testified and been deposed as expert witness on the bankruptcy law. Mr. Avery is a veteran. Thank you for your service, sir, and was on active duty as a major in U.S. Army from 1996 to 1997, at which time he was awarded the Meritorious Service Medal. He was a member of the ABA Subcommittee on Legal Specialization from 2013 to 2016, was chairman of the California State Bar Bankruptcy Law Advisory Commission 2024 to 2025, and was chairman of the State Board of Legal Specialization from 2010 to 2011. It's my pleasure and honor to present you attorney, bankruptcy trustee Wesley Avery.
Debts as they come due. And then what happens next depends on what chapter you file under, and we'll talk about those in a minute. We should, however, talk about involuntary bankruptcy. It is possible for someone to throw you into bankruptcy against your will. This is a very hazardous undertaking for the petitioning creditors, because if you're found to be not insolvent, then they're liable for damages and their attorneys are liable for damages. So this is not for children. Involuntary bankruptcy is a very poor collection device for that reason. However, in my experience, most involuntary bankruptcies are uncontested. And as a matter of fact, if they're completely uncontested, that's a bad sign, because that means there's no money. There's no money to be had. So it's better for it to be contested than uncontested. Anyway, once you file a voluntary bankruptcy, the amount of time that the case is going to last depends on the chapter you file under. Okay, before we get into the various types of bankruptcy, let's talk about the automatic stay. When you file bankruptcy, any actions against you, such as an eviction, are stayed, okay? And whoever is trying to get you evicted has to go to bankruptcy court to evict you and has to get permission of the bankruptcy court. If you are suing someone on a debt, it's probably done. At that point, you can file a proof of claim because the bankruptcy court almost certainly won't give you permission to go to state court and continue a lawsuit. Mindy mentioned to me that there's a lot of interest in tenant bankruptcies. So the important thing is you have to terminate the lease pre-petition. And if you do, you don't have to go to bankruptcy court to get relief from the automatic stay. So the key is being very quick to terminate the lease. Any questions so far? Okay, let's go to the different chapters. Chapter 7. All right, Chapter 7 bankruptcy. I am a Chapter 7 trustee. When you file Chapter 7 bankruptcy, this is more or less the quickest route. And if you have no non-exempt assets and you're honest with me and you're honest with the court, you should be done in 4 months. As a result of the Chapter 7 bankruptcy, you should be discharged from most debts. Certain taxes, child support, alimony, drunk driving judgments, tort judgments if you beat someone up. There are various judgments that and claims that will not be discharged, but most will. One thing you have to be careful is not getting cash advances on credit cards within 60 days of filing for bankruptcy or buying luxury goods within 90 days, because that could be non-dischargeable. So with Chapter 7 bankruptcy, you almost certainly will never see a judge. The only person you will see is me. And we will either meet in person or we will meet by Zoom. And then I have, on average, 3 minutes to figure out if you're being honest with me and whether you have any money. Now, I should tell you that before you and I meet, I have a background check on all debtors from LexisNexis. And I have an asset clerk who works up every case. And she and I and my trustee administrator, the 3 of us, will know a great deal about you before we ever meet. So what we're looking for the most part, is we're looking for real property that you have transferred in the past for no consideration. And the reason why we're looking for that is because we can get it back. And by getting it back, this is how I make a living. Now, not only am I a trustee, I represent other trustees. So the trustees all hire each other to the extent they're lawyers, okay? All legal fees have to be approved by both the Department of Justice and the bankruptcy court and creditors. Creditors have a chance to object before anybody's paid. And we're paid at the end of the case, not the beginning. Anyway, what happens is I find a fraudulent transfer, and then I meet with the debtor and the debtor's mom or whoever the property went to, and say, what are we going to do about this? Seldom is it resolved that way. Usually it goes to litigation. But at the end of the day, I have to hire a real estate broker such as you all to sell the property. And we'll talk in a few minutes about what I look for in real estate brokers. So Chapter 7 bankruptcy is liquidation. With regards to houses that you live in, you have a $680,000 homestead. This has prevented, or this has really changed how many houses are sold. However, it's remarkable how many people say that they live in a house and they really don't. And the background check tells me where you actually live. And they look at utility records, mail forwarding, things like that. But you'd be surprised what a paper trail you create just by paying your bills. So that's Chapter 7 bankruptcy. Any questions on Chapter 7 bank? Yes, go ahead.
One question. You mentioned about transfer of property. So with that life on title, there's also transfer by
Right.
separate property.
Right.
And they loan on the property and then the $680,000 homestead. Are those two added on top of each other?
Yes. They do. The fact that you've transferred the property doesn't make it not community property. However, if you encumber it after the transfer, it's almost impossible, not impossible, almost impossible for me to get that off. As far as the homestead goes, you waive your homestead if you fraudulently transfer a property. So that the bankruptcy law is very complex. There are trustees who aren't lawyers, but they struggle because you've really got to be a specialist in bankruptcy law because you've got both California law applies to a certain extent in terms of property rights, and then you've got bankruptcy law, which is the procedure. And then sometimes things can go sideways from there. Okay, any questions on Chapter 11 bankruptcy? All right. Chapter 12 bankruptcy is just for farmers. Farmers have many rights in the United States. I can't think of another profession where the federal government will pay you not to work. Hard to believe, but true. I'm going to give you an example on the next page of what can be done for farmers. Okay, so that leaves us with Chapter 13 bankruptcy. Chapter 13 bankruptcy is called individual repayment plan. You would have a Chapter 13, you would file Chapter 13 if you have assets such as a business, such as a house with equity above the homestead, and you want to. So there is no trustee taking possession of your property in Chapter 13. Chapter 13s take from 3 to 5 years. Believe it or not, it's possible to confirm a Chapter 13 plan where you repay your unsecured creditors zero. So let's talk about secured versus unsecured. An unsecured debt's like a credit card where you owe money to someone, but they have no collateral. A secured debt is like a mortgage on your house where they can look to the house to repay the debt. It is common in Chapter 13 for repayment plans of zero. And the reason why they're in Chapter 13 is they're 12 months behind in their mortgage. So over 3 to 5 years, they'll get current. With regards to Chapter 7, it is common for people to file bankruptcy multiple times to stop foreclosure. I've got a debtor who is on her 8th bankruptcy. They've tried to foreclose on her house 40 times, and she hasn't paid the mortgage in 10 years. And she's still there. Not unusual, not unusual. So then there are ways where I can force the mortgage company to pay my legal fees. So I can create a pot of money in order to go after this. But this scenario is not uncommon. They say that the bankruptcy court is the devil's playground, and I think there's a lot to be said for that. Okay, I'm on the next page, page 4, lien stripping. You should pay attention to this because this is why a lot of people get involved in bankruptcy. Let me just go through this. A building is worth $3 million and has a first deed of trust amount of $4 million and a second deed of trust amount of $1 million. So it's underwater by $2 million. What you can do in Chapter 11 and Chapter 13 is reduce the first deed of trust from 4 to 3, and you wipe out the second. So you just made $2 million. Now, you cannot do this on a residence except in Chapter 12. So Chapter 12 farmers can do this on their house. Questions? Nope. Individuals and a business. So this is probably one of the most powerful tools in a bankruptcy court, the ability to do this. In other words, rearrange liens and wipe out liens. Any questions? So if you are seriously underwater on real property, but it has positive cash flow, then bankruptcy is an option. I would not get involved in that, me personally, unless the case fails, which is a high probability. Then the case is converted to Chapter 7, it goes to me, and then I see what I can do. One of the main things I need to do is always get somebody on the inside. Go ahead, okay? Then the homestead would cover it. Oh, okay, he asked if you have a house that's worth $1 million and a deed of trust of $500,000, would I administer? The answer is no, because the homestead would cover the equity. So no, you wouldn't lose your house in Chapter 7. Go ahead. Yeah, the homestead has been changed, so it goes up every year, but right now it's around $680,000 in Los Angeles County and Orange County. But it doesn't apply to rental property, and it doesn't apply to houses you don't live in. Right, it's only your primary residence. I wanted to point out that with regards to any case as a Chapter 7 trustee, I'm always looking for someone on the inside who can tell me where the dead bodies are, such as an ex-spouse, an angry girlfriend or an angry boyfriend, a business partner who's been screwed over. That makes it much, much more tenable and easier for me to move forward, because it's common in bankruptcy cases for all the books and records to be in a shambles. That is routine. And although I can hire forensic accountants to try to figure out what went on, and although I can subpoena bank records, that is time consuming. So I'm always looking for someone who can actually point, head this way. You know what I mean? This is where the money is. And that's always my first concern. So when I get a background check, I get also a list of acquaintances, business acquaintances, and telephone numbers and things like that, who have been picked up somehow by the credit reporting system. Oh, I guess you can. You're free to send them the notes. Okay. Okay, so who are the players in the bankruptcy case? Okay, well, there's a trustee such as me in Chapter 7. Now, in Chapter 11, you normally have a debtor in possession. But if you've been bad and people don't trust you, then they can appoint a Chapter 11 trustee to run your case. The Chapter 13 trustee is a pseudo-government employee, pseudo-federal employee, and she, and I say she because most all are women, she pretty much is hands-off, and she just makes sure you make your payments. She also has lawyers that work for her, but it's a much more hands-off thing than Chapter 7, and Chapter 11's in the middle. You've got a bankruptcy judge. Bankruptcy judges do not have a lifetime appointment like district court judges. Bankruptcy judges serve for 14 years. Most have been bankruptcy attorneys. However, some are former IRS attorneys. So we get IRS attorneys as bankruptcy judges. Other players are debtors counsel. Debtors attorneys typically either specialize in bankruptcy or they do anything that comes in the door. And which one you need depends on how complicated your case is. Many people use paralegals like We the People. Some people file bankruptcy on their own pro se, and they struggle, but most get through it. Now, one of the biggest problems with filing bankruptcy is that people don't realize that you have to take a class before you file for bankruptcy, and you have to take a class after you file for bankruptcy. You have to take 2 different classes. And if you don't take the first class, you can't file bankruptcy. If you don't take the second class, you don't get a discharge. And the discharge is the letter you get in the mail, which is sent to all of your creditors that says you don't owe the money anymore. You don't owe the debt anymore. So for some reason, pro se seem to have a hard time with that, even though at the meeting of creditors, they are reminded, you have to take the second class. I would go with a certified specialist, but again, a paralegal might fit the bill too. It all depends what kind of issues you have, and there's somebody after you, somebody chasing you. Now, with regards to the decision to file bankruptcy, there's only two reasons why you have to file bankruptcy. Number one is that you're sued. Okay, if you're sued and you can't pay the lawsuit, you can't defend the lawsuit, game over. Okay, you're going to have to file bankruptcy because once they get a judgment against you, they can start garnishing your wages. They can start hitting your bank accounts. They can put a lien against your house. They can have you called into the court for a judgment debtor exam and take your watch. I mean, there's all kinds of things like that. The second thing is if you can't take it anymore. If you reach a point where the debt collection and they're harassing your work, they're harassing you on your cell phone, they're sending you letters. If you reach a point where you can't take it anymore, that's the second reason. But other than that, you don't have to file for bankruptcy. And if people are making collection efforts against you, you can say, you can write them letters saying, do not contact me ever again. And by law, they can. Unfortunately, they can sue you. They can sue you for the debt, but they can no longer contact you. And so it becomes a question, you know, if I see before me a person in their 20s, I know for sure why they're there. And that's a car repo. Car repo. If a person in their 20s is filing bankruptcy, it's a car repo. And if you have a car repo and there's a deficiency, and there probably is going to be a deficiency, they're going to come after you with a pitchfork. So you're going to have to file bankruptcy, either that or pay the deficiency, one of the two. But car repos are a big cause of bankruptcy. I read the Wall Street Journal every day. I teach finance at Cal State Northridge part-time, so I have to take the Wall Street Journal to stay ahead of my kids. Right now, the interest rate on new car loans averages 7.75%. Remember when it was zero? When it was what? Now it's 7.75%. So to me, that suggests that lenders think that more bankruptcies are coming and a recession is coming. If you look at credit card delinquencies, they're up. If you look at credit card balances, they're way up. And there's all kinds of anecdotal stories of people buying groceries with credit cards, putting it on their credit card. So I personally think bankruptcies are going to increase. Obviously, if the Fed reduces interest rates, that would be a factor, but they seem to be backing off on that. And so they seem to be equivocating now whether they're going to reduce interest rates or not. Interest rates, reducing interest rates are a big way to avoid bankruptcy for many Americans. And the reason why is many Americans use their house as an ATM. They get a home equity line of credit, and then they get a Visa card or a debit card, and they can access that line of credit. So it's free money. Once you bring the interest rates down again, it becomes economical to have a HELOC, home equity line of credit. And then the idea is that when you run it out, hopefully your house has risen in value. So now you can reborrow, refinance, and start the cycle again. And many people have been living that way for years. I'm sure you know these people. But the problem is you can't do that with 8% interest rates, 7% interest rates. It doesn't pencil out. Questions so far? Okay, so let's see. Who are the players in the bank? Go ahead, be dismissed for sure. Go ahead.
Okay, just back to the debtors exam. Can you do that?
Meeting your creditors. A debtor's exam is in state court.
Okay. So that's the state.
Right. In other words, what happens is someone gets a judgment against you. Then they serve you with what's called an ORAP, order to appear. Okay. Then you've got to go to the superior court, not the bankruptcy court, and answer questions under oath. And if you don't go, you can be arrested.
Can you introduce later if you have a judgment against the defendant for the bankruptcy, then that gets presented to you? Or
It does. There is a suggestion of insolvency. If you are served, go ahead.
Sorry, I just have-
That's
I
okay.
need a mic so that on Zoom cannot hear.
Oh, my apology. All right.
People on Zoom cannot- There's, you know,
Okay. All right. Why don't you repeat your question?
Okay, the question is, how do we get a debtor's exam entered into the bankruptcy procedure? So I have a judgment, let's say, against an individual, and now we want to get and he's or she, they are filing a bankruptcy. We now want to get the debtor's exam that we believe they were lying about it, and our investigator actually found assets. How do we get that before the trustee?
Okay, well, first of all, great question. First of all, the trustee would welcome that kind of information. But there are legal implications of an ORAP, which is an order to appear. First of all, it gives you a lien. It gives the judgment creditor a lien on all personal property. If the debtor files bankruptcy within 90 days, that lien's wiped out. So you hope that the debtor waits more than 90 days to file bankruptcy. At that point, then you've got a lien on the personalty. Hopefully you've recorded your judgment with the county recorder, in which case you then got a lien on all real property. Liens on other assets such as cars, you go to the Secretary of State in Sacramento. So anyway, at this point, what you would do is you would approach the trustee, and if you are secured or unsecured would make a difference in terms of what your rights are. Nevertheless, bankruptcy trustees are deal makers and they are in the make it happen business. So if you have a proposal, the bankruptcy trustee will negotiate with you and then will take it to the bankruptcy judge for approval in terms of splitting money between the estate, how much you get, how much the creditors get, etc. Okay,
Mr. Avery, we have a question on Zoom.
go ahead.
At what point do you discuss using a 522F for avoiding a judgment lien?
Trustees can't do that. Debtors' attorneys can. So what happens is you file bankruptcy and you've got various creditor liens. I am a non-practicing real estate broker. I have a real estate broker's license. I don't practice. However, you could not do my job without a real estate license. So I have access to the real estate databases. So I go and look at the liens, and as you know, you can pull the liens up, and I look to see if they're phony. These are consensual liens. Judgment liens aren't available on the real estate database. So my first thing is I look to see if you've put phony liens against your house, and if there's phony lien against you, either judgment liens or consensual liens. For example, do you owe money to Santa Claus? You know what I mean? Or the King of Mars or something like this. Or is it your mom? You owe $1 million to your mom. Now, if I detect that you have these liens, so these liens are called comfort liens. This is the industry vernacular. In my world, we call these comfort liens. I can attack these liens using a variety of legal methods, and then that lien becomes my lien. So now I have a lien against the house, me, Wes Avery trustee, which is ahead of your homestead. So by recording phony liens against your house, you can lose your homestead. This is why debtors' attorneys have to be very careful in their interview to find out what's legit and what isn't. But Mindy, to answer your question with regards to 522F, if I determine there is no money for unsecured creditors, then the debtor's attorney can then file a 522F motion and strip liens, judgment liens, not consensual liens, judgment liens from the house. In general, the chances of the debtor winning these 522F motions are between 80 and 90%. They almost never, ever lose. And for this reason, they are seldom contested. Does that answer that person's question?
So we have another question for you from
Okay.
Jacqueline. She does escrow. Hello, I do escrow, and sometimes we see recorded judgment that were never issued with satisfaction. And clients tell us the judgment was included in the bankruptcy, and the bankruptcy have been dismissed. But when we contact the creditors for satisfaction, they would send a demand. It seems the debtor at that point has no choice but to pay the demand, or we can't get a satisfaction to close escrow. What should have taken place during the bankruptcy proceeding? Does the attorney represent the debtor have to specifically ask the court to have a creditor to remove the judgment? Otherwise, too bad, so sad.
Okay, there were a lot of issues there. So if we're talking about judgment liens only as opposed to consensual liens, once you record the 522F judgment, they will disappear because whether a lien appears on an escrow is a function of the title company, not the court. So once the title company sees the 522F judgment, it'll disappear. With regards to ancient liens, in other words, older liens, there are state laws that deal with very old liens. They become invalid depending on what kind of lien they are after a certain period of time. I would point out that while I use many brokers, I only use one escrow for all my deals. All my deals is this one guy, and this one guy also is the escrow officer for many other trustees. And the reason why is we can't be stolen from. That would be catastrophic to our careers. So any kind of phishing attack, things like that, he can just pick the phone up. He has my cell phone number and he can just talk to me directly. You know what I mean? What's this? So bankruptcy trustees aren't stolen from, but that's always, a possibility. Also, he's very good at detecting problems and he protects me. So I appreciate that. So very seldom do we have any kind of problems with liens that we can't resolve. Realize that there is no stronger or better entity in the world for getting rid of problem liens than the bankruptcy court. That's what they do.
Thank you. And I think Joe, he's from Orange Title. He's the one who asked you that questions about the 522.
Can I say something about Orange Title?
He's
Orange Title is really good in problem cases, and I'm an admirer of them.
he asked if he can speak and ask you another question.
Go ahead.
Can
That's
you
up to you
unmute
guys.
him? Thank you. Thank you, Berlin.
All right.
Go ahead, Joe.
They are different than all the other title companies, but usually I use First American.
Oh, okay, thank you. I was trying to unmute myself. No, it's about the question I had about the 522F, and it absolutely ties into Jacqueline's question. But I was just because we get a lot of times where we're in escrow close to closing, and the judgment, we see the judgment and they say, oh, well, we filed bankruptcy. But they didn't get the 522F. And so I guess my question is more like for the debtor's attorney, like, are they supposed to, because I know you guys can't, I guess from what you said earlier, you can't search if there are judgment liens against these individuals, but the title company.
The title company can, if you give the title company the social security number and or driver's license, but bankruptcy trustees can't. Now, let me just say this. Sometimes on a LexisNexis report, you'll see a judgment and sometimes you won't.
Okay. Yeah, I guess my question was more like, why do these individuals who filed bankruptcy get so far after their bankruptcy has been completed and they didn't get the 522F? Does it come up in the beginning? Do they ever try to talk about it? Because we see it all the time where they have to go and reopen their case or maybe not reopen the same case, but they have to go back to court for a couple months to get the 522F, and they do usually always get it, like you said. But like, is it the client's fault, or did the attorney fail to maybe address it in the beginning?
You get what you get what you pay for. If you pay an attorney $500 to file, just skeleton filing, he or she is not going to look very deeply into your affairs.
Okay.
Is there a duty to file a 522F motion? Not generally, no. So what
Hmm.
happens? What happens is that the bankruptcy goes through. I might ask you, are you going to try to strip the liens? But most trustees wouldn't. But I might ask you that at the meeting of creditors. So then your case closes, and then a year or two goes by, and then you're at a cocktail party, and someone says, well, why don't you refinance your house or sell your house? And then you get a title report, and then you see the liens. And
Yeah.
at this point, you can reopen the bankruptcy case. I
Hmm.
would not be involved unless there's fraud. If there's some kind of monkey business, then I'll be reappointed. But I will check and make sure the liens are legit when the case is reopened to make sure this isn't a scam. And then you would just proceed without me and wipe out the liens. So that's your question.
Yeah, thank you. Thank you.
So what I'd like to say about Orange Title is that I had a case where I was selling a cannabis or a building that had a connection to cannabis. And you were the only company that would issue title insurance. So I was very grateful.
Oh yeah, that's something we have a special product for that, basically, that we have special exceptions we add to our title policy for insuring cannabis properties.
As far as I know, you're the, unless I'm wrong, and you would know better. As far as I know, you're the only one that does it. Is that correct?
Uh, I I can only speak for my company. I know that there's another company that supposedly does it, but they don't have a brick and mortar office in California.
Thank you. Any other questions, Mindy?
Yeah.
Okay, thank you.
So one of the participants asked, do you give free consultations for BK?
Yep.
How much is the cost and how long does it take in effect?
My cell phone number's on this handout, so you've got my cell phone number. It's on the second page. I give free consultations, but for me to get involved, there'd be two reasons. Number one, you're very, very scared for whatever reason, and you don't want anything to go wrong, or you've got a significant problem. But if you're just trying to discharge credit card debt, you probably don't need me. However, you've got my cell free. Feel free to call. Any other questions? Okay, so let's talk about tenancies for a minute. Okay, so tenancies can arise two ways in a bankruptcy. Either the lessor can go bankrupt or the lessee can go bankrupt. If the lessee goes bankrupt, I attempt to figure out if this is an under market lease. If it's an under market lease and if it's worth my while, I can assume and assign the lease to a third party without the lessor's permission. But I'm going to need an order from the bankruptcy court. I would try to do that consensually, but this is more in corporate cases, especially like the Kmart bankruptcy or the Sears bankruptcy or big bankruptcies like this. Now, I should point out that if you are the lessee, bankruptcy is a great way, Chapter 11, to get out of a lease, because whatever money is due and owing on the lease, you might end up paying only 20% of the amount due. So Chapter 11 is known as a way of getting out of commercial leases. Any questions on that? Being a lessor, if your landlord files bankruptcy, in general, your rights will be unaffected. The landlord does not have the right to cancel the lease. You have the right to continue on with the lease. And so in general, there'll be no effect. Let's see. What do you do if a seller client declares bankruptcy in the middle of an escrow? This comes up quite a bit. So what's happened is this. You've got a short sale and the real estate agent is doing a short sale. And then for whatever reason, the seller declares bankruptcy right in the middle of the short sale. And so then I get a phone call from the real estate agent saying, will I abandon the property? Now, abandonment means that there's an order of the bankruptcy court that says that this house is no longer property of the estate and is reverted back to the debtor. Okay, this takes a lawyer to do it. This is a no asset case. I'm not getting paid, so the answer is no. But if you want to hire a lawyer and go do it, I won't oppose it. At this point, I usually double check. In other words, the rule is never call a bankruptcy trustee ever with a question, because then the bankruptcy trustees think, why is this person calling me? Does this person have something? You know, and we always double check. In other words, then we go through again and look at this. So if on this house, someone called me and said, you know, will you abandon it? Obviously, I'm going to recheck the numbers. And now I'm going to start looking at the liens and see, is this legit, not legit? I might also use my real estate contacts to find out more about the real estate agent who's calling me. Is this person honest, not honest, etc. So what I will do is at the meeting of creditors, I will no asset the case. So what does that mean? That means that I send an electronic signal to the bankruptcy court that says there are no assets to administer, in which case then the closing process will begin, and hopefully you will file proof of your second bankruptcy class. So what I will do is no asset the case. All title companies will accept that and will then allow the short sale to go through. And I can't in memory remember any title company demanding that there be an abandonment order. Questions on that? Okay, what do you do if a buyer client declares bankruptcy in the middle of the escrow? Well, that's kind of an interesting situation because obviously if it's a good deal, I could theoretically step into the shoes of the buyer. However, what I would do is I would find someone to take my position for consideration. In other words, I'm not supposed to be running businesses. I'm not supposed to be borrowing money, although I can with a court order, you know, but typically I would find someone to take my position for an amount of money and then just shift it over. The secret in my business is to never touch anything. You never touch anything. And you only, when you do touch something, you touch it at the last minute just before you transfer it or sell it to a third party. Once I get possession of a house, I have to get insurance, and I do that on my own nickel. I have to pay for that, but then I can get the money back through an escrow. So it's kind of a delicate dance, knowing when to take possession and when not to take possession. Let's see, let me tell you a funny story. There was a guy who was a debtor, and he owned a house on Sunset Plaza. Anybody know what that is? Beverly Hills. It's a very exclusive area. So he was up in the hills there, and he had kind of a shack, but it had a wonderful view. And the IRS had been trying to execute on the house for years and had been unable to do it. And he was what's called an industrial doctor. I don't know if you've ever run into that. It's a doctor who works in a large factory. And what his job is if you hurt yourself, he comes and looks at you and says, man, you look hurt, you better go see a doctor. It's actually a very cushy job. Anyway, so I went up there and I found he had changed the house numbers on his house. So he'd changed the number, you know, from 4,000 to 4,008, and that was enough to fool the IRS. So I went and looked at him, and I figured out it was his house. Knocked on the door, and he knew who I was. I said, hey, someone's changed the numbers on your house. He said, really? I said, yeah, look at this. We sold the house. I go and inspect everything personally. if I'm going to sell it. Let's see. What are the requirements for the bankruptcy court to approve a real estate sale? Okay, so let's talk about quickly you representing me. What do I need for you to represent me? First of all, you have to protect me and the court and the Department of Justice. And you have to keep an eye on the house. And if someone's running a meth lab in that house, that is your job to figure that out, okay? Or if people are stealing the fixtures, because once you've got the keys, that is your responsibility. If a dishwasher disappears, you're going to replace it. Okay, because you got the keys. On the other hand, you don't have to pay me anything for the listing. You know what I mean? In other words, it's a free listing. There's no advertising cost or anything like that. And once you become well known with one trustee, you start being picked up by other trustees. Why? Because trustees represent trustees. So if you are good, that gets around. The next thing is, it is appreciated if you get the debtor out. In other words, we can use the U.S. Marshal Service, and we do, but it would be better if you cut some kind of cash for keys deal, something like that. So we're talking about a situation where there's no homestead for whatever reason, because if there's a homestead, they're getting $680,000. So we're talking about a situation where somehow there's no homestead, in which case, whatever you do, cash for keys is up to you. But if you are unable to do that, I will not hold that against you. And I will do it, which means I have to get the U.S. Marshals, which means I have to go there. And I have no problem doing that, but I don't want to do that every time. So I expect you to be proactive and negotiating with the debtor in terms of when are you leaving, do you need help, do you need a truck to move your stuff out, etc. Now, the funny thing is, the requirements are no collusion, so it can't be an inside deal. In other words, if you're a real estate broker for me, you cannot keep selling to one person, an investor. That is a no-no, no, no, no. Once the bankruptcy court finds out about that, so it's always got to be a new buyer. The sale has to be in the best interest of creditors. It doesn't necessarily have to be fair market value. It should be at least 70% of fair market value. But it doesn't have to be fair market value, which is why people are involved in this, because they can get bargains. And the real property has to be adequately marketed. And notice the sale to creditors has to be proper. In other words, we've got to put in evidence to the court of what you did to market the property. I've been with brokers for many years. But I'm always looking for new people. New slide. Questions? Thank you very much for inviting me. I hope you learned something.
Yes, thank you. Anyone last minute, last chance? Anybody on Zoom? Thank you very much, Mr. Avery. On behalf of WSGR Education Committee, a certificate of appreciation for your time and your knowledge. Thank you so much.